5 seconds. Start. In the counter affidavit filed by the CCI, it was explained that there was an overwhelming response received from the candidates for selection to the aforesaid post, and having regard to the large number of applications received, the CCI decided to undertake the selection to all posts notified in the advertisement on the basis of written test followed by interview, and accordingly it was determined that written test would be for 80 marks while 20 marks were attributed to interview. Further, candidates who secured minimum of 50 marks in the written test in the general category and minimum of 40 marks in the reserved category were called for interview in the ratio of 3 times of the number of vacancies, where the number of vacancies were more than 10 and 5 times of the number of the vacancies for less than the 10. The marks obtained in the written test were not disclosed to the interview committee, and the committee, independently and without being influenced by the marks obtained in the written test, adjudged the candidates on the basis of viva voce test and awarded the marks. The marks of the written test, which were kept in the sealed cover, were opened after the marks given to candidates in the interview by the interview board, and tabulated merit list was prepared accordingly. The CCI, keeping in view the nature and purpose of the post, decided to fix the percentage for final selection were 70 marks out of 100 for unreserved category and minimum 65 marks out of 100 for reserved category for professional categories, in which category the post of Deputy Director Law falls. It was argued that such a course of action was permissible, and it was not a case where the mode of selection at any time was changed, and insofar as fixation of benchmark is concerned, that was prerogative of the employer. The learned single judge of the High Court accepted the plea of the respondents, as he did not perceive this to be the change in criteria in the selection procedure, holding that fixation of the benchmark was legal and justified. In the aforesaid backdrop, the question that falls for consideration is as to whether fixation of benchmark would amount to change in the criteria of selection in the midstream when there was no such stipulation.